I'm just adding something that's come in since I recorded most of this video, which is that Long Island Audit has apparently been arrested. Let's read it, and I can't do his accent. Fellow patriots, I was unlawfully arrested yesterday by the Nassau County, New York Police Department for peacefully exercising our constitutional rights in public. My freedom was taken from me for over 6 hours and my property stolen from me. We all know that this arrest was pure retaliation for exposing them the day before. I was arrested by Officer Keller of the 3rd Precinct, the same officer from the original audit. If you haven't seen the video of my original audit of the Nassau County Department of Human and Health Services, I highly suggest you do so here. I will go in live today at 6:30 p.m. Eastern Standard to explain everything in detail. There's a lot to go over. Make sure you have notifications turned on, because trust me, you're not going to want to miss it. Fellow freedom lovers, when is this tyranny and corruption going to end? I treat everyone, including our public service, with nothing but respect, yet I continue to have my rights violated over and over again, while peacefully exercising them to promote transparency and accountability within our government. Make no mistake, if the government will do this to me knowing that I have the full support of we the people, they will do it to any one of you, the next time you want to peacefully exercise your rights. Well, that's enough for stupid. Maybe more details will come out. On to Earl David Warden. Well, Warden's appeal brief is in. This is a brief to the appellant court. It's 78 pages in all. And I'm going to start at page 36, which is a summary of the argument. Whether we go back and do what has come before, I'm not sure. I'm going to start here. I don't know if I'm going to go through all the arguments, but we'll start with the summary and see how we go. Right. Warden was prosecuted for a nearly 25-year-old allegation of sexual assault, where there was no physical evidence, no corroborative evidence other than that the Warden family lived in a specific trailer park, and where the complainant's allegations were contradicted by other state witnesses and seemed implausible to have occurred hundreds of times, like she now recently claimed, over a 2-year span in a small trailer with 7 other family members home, but where no one ever reported seeing a single act of sexual abuse committed. To get around the lack of evidence for the charged offence, the state argued that trial counsel's opening statement to the jury opened the door to alleged extraneous bad act evidence. The state's argument succeeded, and the trial court admitted the bad act evidence over defence counsel's objections and his protestations that he had not opened the door, that the evidence did not fit within the open door, and that it was never his strategy to open the door to the alleged extraneous conduct. Warden presents that the admission of this extraneous bad act evidence violated Texas Rule of Evidence 404, 403, and that any opening of the door to this evidence constituted ineffective assistance of counsel. Warden, a well-known police accountability publisher, had his trial attended by several fans and anti-fans. The trial court was aware and concerned with the dangers of outside influences impacting the jury. Those concerns came to fruition through the actions of attendees shouting inflammatory remarks within earshot of the jurors, following jurors to their cars, communicating with jurors, and even through the comments and remarks of the trial court itself. These outside influences brought to bear on the jurors violated Warden's right to a jury trial, his right to due process, and violated Texas statutory law. The state also injected Warden's trial with unnoticed, inflammatory and inadmissible evidence of alleged racial and religious animus. Having a black prosecutor present evidence and argue to the jurors, 4 of whom were black, that Warden would not allow his wife to live at their trailer home because she was impregnated with a black child, and that Warden refused to allow the black child into the home, but instead that the child had to be given up for adoption before the wife was allowed to return to the family. on account of the child's race and the contention that Warden was racist. The state compounded this with contentions that Warden was a Mormon and that he tried to get the complainant, his daughter, to convert to Mormonism so that he could marry her, suggesting to the jury that it is acceptable in the Mormon church to marry one's own children. These presented attacks on race and religion, violated Warden's First and 14th Amendment rights, and the failure to object to this evidence constituted ineffective assistance of counsel. The issues are presented herein. Arguments and authorities. 1. The trial court erred in admitting the extraneous offence evidence, as trial counsel did not open the door to such evidence, and if he did, the admitted extraneous offences did not fit within the opened door. The trial court erred in admitting the extraneous offence evidence in violation of Texas Rule of Evidence 404(b), as trial counsel's opening statement did not open the door to such evidence, and even assuming arguendo that trial counsel did open the door, the admitted extraneous offences would not fit within that open door. As discussed in Statement of Facts, Section C-1, trial counsel stated in his opening statement that 1. It was not possible in a trailer with 7 other people for sexual abuse of BW to happen almost every night for 2 years without any other person in the house ever noticing. 2. The story changed drastically from the original story 22 years earlier. And 3. There was no benefit to BW for the original story, as she was able to move to her grandmother's trailer, enabling her to see her boyfriend outside the supervision of her parents. And there's a subnote 4. The original story was not an allegation of sexual assault, but alleged touching or attempted touching of BW's breasts, and which allegedly took place when BW was over 17, no longer a child under Texas Penal Code 22.011. As such, this alleged act was extraneous to the charged offence and could not support the conviction either factually or legally. Thus, trial counsel's opening remarks concerning Brandy's original story were collateral to the charged offence, and the state would not be entitled to present impeachment or rebutting evidence of the collateral matter. And there's some references. The trial court found that trial counsel's opening statement that focused on the credibility of BW's story, aiming at the impossibility of 600 alleged instances of sexual assault going undetected for 2 years in a small trailer with 7 other people, opened the door to extraneous offence evidence that 1. BW witnessed Warden groping, touching and putting his hand up JW's skirt, which JW herself directly denied. JW was called into a room and told how to masturbate with a Coke bottle, which was alleged to have occurred a singular time in the direct presence of her mother and state witness SW. Over the several years that they lived in the trailer, Warden walked into the restroom while JW was using it on 2 or 3 occasions, and immediately stated, "I'm sorry," turned around and walked out. Warden touched JW's leg mid-thigh while she was driving, telling her to press the pedals of the standard transmission car. Texas law is well established that evidence of other crimes, wrongs or acts is not admissible to prove the character of a person in order to show action in conformity therewith. Texas Rule of Evidence 404(b). Such evidence can be admissible for other purposes, however, including to rebut a defensive theory brought about in opening statements, but that extraneous conduct must be at least similar to the allegations of the charged offence. There's references. First one, recognising the extraneous misconduct must be at least similar to the charged one. Next reference, recognising that there must be a degree of similarity between the extraneous misconduct and the allegations of the charged offences. And finding that touching the butt over the clothing is not sufficiently similar to penile penetration of the sexual organ that it logically serves to make it more or less probable that CE lied. An accused may not be tried for a collateral crime or for being a criminal generally, and extraneous offences are inherently prejudicial and raise the possibility that the defendant will be convicted for his propensity to commit crimes rather than the specified conduct which is charged by the state. Okay, that's the end of the references. To determine the proper scope of the rebuttal evidence, it is critical to first identify what specifically is being rebutted. Trial counsel's assertion that BW's story lacked credibility based on the impossible likelihood that someone could be sexually assaulted hundreds of times over 2 years in a small trailer with 7 other people without any of those people ever seeing anything, no witnesses, no detection, no observations, no suspicions. The state's offered extraneous rebuttal evidence did nothing to rebut trial counsel's opening statement and were not sufficiently similar to the allegations of the charged sexual assault offence to warrant the admission of those extraneous allegations into evidence. Rather, the offered extraneous bad acts were nothing more than propensity bad act evidence. In fact, 2 of these prejudicial extraneous bad acts supported trial counsel's argument, as those acts were alleged to have taken place out in the open in front of other people at the trailer, which is exactly what defence counsel said would be expected, for instance, in a small trailer with 7 witnesses around, that someone would have seen something. In essence, such evidence was not rebuttal at all. It supported defence counsel's contention, but still constituted harmful propensity evidence. With respect to BW's alleged observations of Warden with JW, which JW herself directly denied, the purported groping and touching under JW's skirt is alleged to have taken place openly and in front of other people, not repeated surreptitious sneaking through the house and into a bedroom in the middle of the night to engage in sexual contact. The same is true with JW's Coke bottle allegation. This was alleged to have taken place a singular time in front of another person who notably did not give any testimony to support the allegation. JW's allegation that Warden walked into the restroom while JW was using the bathroom on 2 or 3 occasions and immediately stated, "I'm sorry," turned around and walked out, also fails to contain sufficient similarity to the charged offence and is merely propensity evidence. There was no evidence to support or suggest that this was intentional or sneaking around conduct that was aimed at being sexually assaultive conduct. Finally, JW's allegation that Warden touched the middle of her thigh while teaching her to drive also is insufficiently similar to the allegations of the charged conduct. No nexus connection or similarity to the sexual assault allegations made by BW. Harm. The admission of these extraneous bad acts harmed Warden, affecting his substantial rights and having a substantial and injurious effect or influence in determining the jury's verdict. In assessing the likelihood that the jury's decision was adversely affected by the error, an appellate court considers the entire record, including testimony, physical evidence, jury instructions, the state and defence theories, closing arguments, and important factors, including the nature of the evidence supporting the verdict, the characters of the alleged error, and how it might be considered in connection with the other evidence in the case, and also whether the state emphasised the error, and whether there was other overwhelming evidence of guilt present. An analysis of these factors illustrates the introduction of the extraneous offences harmed Warden's substantial rights. There was no physical evidence to support BW's nearly 25-year-old accusation. Detective Reed found no supporting records to corroborate BW's allegation. No police reports, no CPS records, no forensic interviews, no medical records, no therapy records from the therapist she claimed to have visited and who would have had a duty to report such abuse, and no support group records from the group she claimed to have attended. The testimony reflects that BW's story was also inconsistent and contradicted by nearly every witness, including the state's witnesses. Detective Reed confirmed that BW told him the sexual abuse began when she was 14, when she would have shared a room with her sister JW and occurred nightly. Detective Reed also confirmed backed by his recorded interviews with BW, that he never told BW anything about the statute of limitations changing, despite a claim that he informed her there had been a change. Detective Reed and SW, her mother, also confirmed that BW never said a single thing about the alleged sexual assaults to any family member until Detective Reed's investigation began, contradicting BW's claim that she had told her family about this back in the late 1990s. Ultimately, the testimony reveals that BW gave contradicted and inconsistent testimony about where the sexual assaults occurred, when they occurred, who she told, when she told people, what people told her, and that the reactions of licensed professionals upon telling them of the abuse was that they ignored their legal obligation to make a report. The testimony also reflects that BW's story changed regarding the frequency of the alleged sexual assaults, that originally it was virtually every night when she talked to Detective Reed, but had whittled down to 3 times per week when BW was confronted with the absurdity of her allegation that she was sexually assaulted 600 times in a small trailer with 7 other people present, but no one ever heard or saw a thing. BW's story was similarly refuted by the testimony of defence witnesses MK, SB and DW, who were familiar with Brandy's reputation for credibility, were aware that she had denied that Warden had ever sexually assaulted her, and aware that the layout of the house did not support BW's contention that Warden snuck into her room virtually every night for 2 years. DW slept on the couch, was a light sleeper, and could see directly into the lit hallway. The state's theories and arguments rested heavily on the alleged extraneous acts, and the state relied upon them heavily in its trial evidentiary presentation and closing arguments, discussing BW's alleged observations of Warden with JW, that again JW herself denied, the Coke bottle masturbation allegation, the allegations that Warden walked into the bathroom while JW was using it, which made her afraid to use the bathroom, and so she started peeing on a pile of clothes in a closet, and the allegation that he touched her leg when she was driving. The jury instructions further exacerbate the adverse effect of the alleged extraneous bad acts, stating that the jury can consider those acts for purposes of determining BW's credibility by rebutting a claim of fabrication or lack of opportunity. Even when 2 of these alleged extraneous bad acts were said to have occurred in front of other people. Finally, it should be noted that the harms of the improper admission of Detective Reed's credibility opinion, the improper racial and religious animus presentation, and the trial court's improper commentary should be weighed in conjunction with assessing Brandy's testimony. Warden requests this court find that the trial court harmed Warden and improperly admitted the alleged extraneous bad acts, that the door was not open to those acts, and that they did not fit within the open door. Warden requests this court grant relief on this claim, find that his substantial rights were violated, and grant him any and all further relief to which he may be entitled, including vacating his conviction and remanding for a new trial. Right, that will be the end of part 1.
Thanks for watching.